Am I understanding this is an application?
Yes, ma'am.
Malik Hatch.
Welcome back to the courtroom, folks, and today, we're stepping into the case of State versus Cami Lynn Lumpkins, a mother, a defendant, and a story that's anything but simple. Charged with possession of a controlled substance, Cami faces the kind of crossroad that can change a life forever. But this isn't just about drugs, it's about responsibility, motherhood, and the fight to earn back trust. Stay locked in.
Court is calling 2025 CR 010462. State versus Cami Lynn Lumpkins. Can I have parties announced?
Megan Gowley for the state.
James Tochi for Ms. Lumpkins, Judge.
And are you Ms. Lumpkins?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lumpkins, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Lumpkins, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No contest, Your Honor.
No. My question is, did you intend to give up those rights that I've just mentioned to you? Do you understand those rights?
Yes, ma'am.
Are you asking the court to allow you to enter into a plea bargain agreement with the state?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Lumpkins, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied re-entry and naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. They will take in consideration 2025 PF 25148, 2025 AL 006849. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, no contact with
Xiomara
Xiomara,
Perales.
Xiomara Perales, life skills course, parenting classes, and prohibited possession of firearms. Did you understand those were recommendations from the state?
Yes,
And
ma'am.
the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
State for states one and attachments.
Thank you. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
This is where her attorney tries to humanize her, bringing up her child, unemployment, and even her parenting class. It's a classic defense tactic. Show the judge remorse, show progress, show potential. But notice the shift when the judge learns she signed over her parental rights. The tone hardens. Judges often see this as a temporary escape hatch, a way to dodge child protective services. You can almost feel the disappointment in the room.
Just a couple things, obviously, that the court follow the agreement. I don't believe Ms. Lumpkins has any history prior to this. She does have a minor dependent, Judge. I know that there's a fine, and I should have mentioned this earlier. She's not employed. She does care for the 3-year-old dependent. You could perhaps help her with her fine. And she took a parenting class already while in custody. Just wanted to make you aware of that.
All right. So you have a 3-year-old dependent?
Yes, ma'am. But
And it-
I signed over my temporary rights to my mother as well as my husband.
And I'm assuming Child Protective Services is involved?
They were involved, but they closed the case as soon as I signed over the rest to my mother.
All right. So I'm telling you all, what's the child's name?
Roman Lumpkins, RHOMEN LUMPKINS. And his middle name is Connor, CONNER.
So it's Roman Connor Lumpkins? All right. So it appears to the court that the only reason why Child Protective Services is not in her life is because she signed over rights to her mom.
Yes.
So I'm not going to do this thing where you signed over your rights to your mom and then you go back and say, let me take my child back. Oh, well, I'm going to make sure that doesn't happen with conditions. So when's the last time you had employment?
The last time I had employment was about 6 months before I got incarcerated. I was donating plasma to help keeping my benefits and as well as giving my son clothes and shoes that he needs.
All right. What benefits?
EBT and Medicaid for him.
All right. So then you didn't have employment. What was your employment?
I let them know that I was just donating plasma and I would get $60 to $75.
Okay. That's not employment. So when's the last time?
6 months before I got incarcerated.
Doing
So
what?
I was working at Babes Old Fashions restaurant.
Okay. I always see that restaurant. I've never gone in and tried it because usually I'm passing by.
Kids eat free.
Oh, so you've been. Okay.
Yes.
Well, let me bring out my pigtails. During school.
I only went to 10th grade.
All right. Why?
I was never really involved with school. I was always just running around doing a little hoodlum. Instead of doing education, I was just running amok.
So what are your plans? Because you have a child.
My plan is to get a GED and show him that his mom can turn around her mistakes and better herself.
All right. So you're going to have to reside somewhere other than your mom's.
I don't have anywhere else.
Well, here's the thing. I'm not, at this point in time, I can't trust you with your child at this point in time. I mean, it's a no-go for the court. This is what the court is going to do. There's $1,000 fine that will be probated. Court will sentence you to 4 years deferred adjudication. There's to be 100 hours of community service restitution. Ms. Abrams, the parenting classes at the jail is not going to count towards her parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied if she obtains her GED. If for some reason you're unable to obtain your GED, then you're going to have to do those 50 hours. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no unsupervised contact with minors. There's to be no residing in household with minors. There's to be no contact with Xiomara Perales, course. Take into consideration 2025 PF 25148, 2025 AL 006849. The following will be done in custody. There should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow TAP recommendations and field visits one time per month until further notice, or that can change if she's accepted in felony drug court, because they will do their own field visits. I'm sorry, what?
How many months of field visits?
Until further notice. All right, Ms. Abrams, is there anything else? Thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And what I can tell you, because you don't have custody of your child is not with you, so those benefits should stop for you.
Yes, ma'am.
Did you read the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. Here's the thing.
And here comes the final hammer. The judge unloads raw truth, reminding Cammie that driving a stolen car with drugs and a 3-year-old in tow isn't just illegal. It's endangering innocence itself. Her defense collapses, and the judge makes it clear. No more easy outs. It's firm, emotional, and brutally real, the kind of courtroom moment that stays with you.
That 3-year-old can't even fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perales person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old, impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen.
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. She's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
On and off for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I would be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old? If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. Not in this court. Good luck to you. Who's here on Beverly Zuniga?
Ready, Your Honor. James C. Lawson.
All right, the court is calling 2022 CR 2568. Can I have parties announced for the record for the state?
Melissa Albin for the state.
James C. Law for the defense.
And I'm so sorry. The style of the case is the state versus Beverly Marie Zuniga. And are you Beverly Marie Zuniga?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beverly Marie Zuniga who was placed on community supervision in 2022 CR 2568 for the offense of assault family second offense on April 14th, 2022 for a term of 5 years? Is that you?
Yes.
All right, state.
We're going to proceed on number 38, Your Honor. In Bexar County, Texas, the defendant, Beverly Marie Zuniga, did then and there fail to report weekly for a period of 3 months as directed in violation of condition number 38.
How do you plead to that? True or not true?
True, Your Honor.
We'll waive the rest, Your Honor.
Any objections to the waiver?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 5 years in the prison and a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition 38?
Yes.
Court will find violation of condition number 38 true. Is there a proposed agreement?
There is not, Your Honor. I
We're
believe
going to open.
we are recommending revocation and the defense would like to ask for something else.
All right, defense.
If the court is going to revoke, we ask the court to do less than 5 years. She's currently taking medication for a heroin problem. And apparently she's doing quite well on that. She's got a couple of children, the youngest being 17. So I asked the court for a little mercy in this matter and asked for credit for time served also.
All right. So probation, what has she done?
Your Honor, can we have just a few moments to step back and review the court summary?
Sure.
Thank you so much, Judge.
All right. So defense, it's my understanding from the state they're recommending revocation. What are you requesting?
I'm asking you to, pardon?
The state's recommendation is to revoke and sentence for 5 years, TDC.
All right. And so what are you requesting?
I'm requesting less time than 5 years, 2 to 5. I'm asking, and I want to point out that she's 40 years old. She's taking a drug right now, a prescription drug to help with her heroin. And she's doing very good on that. She has a couple of kids, the youngest being 17. And I asked the court for mercy.
All right. So is there anything you wish to say to the court?
If given the chance, would you go for?
Well, if she wants to say anything,
Okay.
then she'll need to be sworn in.
Okay.
Oh, yeah, I was saying.
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Beverly Marie Zuniga.
All right. And probation, she has pled true to violation of condition number 38, and the
30.
court has found that true. All right, what would you like to say?
I was letting my lawyer know that I was likely to get my GED because I didn't finish high school. And also my grandmother, she like relied on me. She has a pacemaker in her heart.
Mhm.
She's 87 years old. I don't have my parents. They passed away when I was very young. She's my only.
So let me ask you this. If your grandmother is relying on you, why would you come to me? And this is your third motion to revoke. And let me just remind you, your first motion to revoke was a violation of condition number 2.
Yes.
The court denied the motion, alternate amend conditions to get you drug treatment. Then your next violation was a violation of number 4. The court alternate amended your conditions and continued you. And now you're back here for another motion to revoke. So why were you not thinking of your grandmother needing you before?
No, I have been, but I had a stroke myself, and as you can see, my right hand is stayed messed up, and I have this on my eye from when I fell. This happened in October. It's been like trying to take care of myself and take care of my grandmother. It's been really hard, and then with my kids. My daughter, she has lupus, the 17-year-old. She's in college. She just finished school. She doesn't have a father. She just has me.
Mhm. All right. So this is what the court is going to do. The court is finding violation of condition number 38 true. The court is going to grant the motion. There should be no contact with Paula Pena. There's an affirmative finding of family violence. The court will give you credit for any time served, credit for any time served in inpatient treatment, and the court will sentence you to 5 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you, Counselor. Edward Valdez.
Evening, Counselor Young. Good morning.
This is an old case. Is this a motion to revoke or is this?
No, this is just a setting, Your Honor.
It's a ninth setting. There's an application for PTD, Judge. We've resolved the case. So
Oh.
we're going to send that application in today. And he has an MTR in County Court 7. And I'm going to ask that he be held in 1.5 so we can resolve that also.
All right. I need a PTD date.
Can you do that November?
I'm sorry, when?
November 6th?
Okay.
With the judge.
November 6th. So you need to make sure you follow through on that and everything is completed. Do you understand? And then, does he have a warrant for this case?
Joel?
I think so, Judge. No,
Okay. All
he
right.
was remanded without bond though on this case.
So does he have a warrant on this case or not? All right, y'all need to check because otherwise he's not going to be released. All right, thank you.
Does
Just
he
have
have
a seat. Okay. Nicholas Cornelius, we're going to go on the record in 2021 CR 083